Hello, good afternoon and good morning, and welcome to McGuire Woods Food and Product Labeling Litigation and Regulatory Update Valentine's Day edition. I am Trent Taylor, and I will be one of your hosts for today's webinar. And we're so happy that y'all are able to join us today. And as most of you probably know, we aim to do these events about once a quarter or so, in order to keep our clients and friends apprised of what is happening in these spaces. Here is sort of a brief roadmap of what we're going to be doing today. First of all, I'm going to give a brief intro, and then I'm going to turn it over to Royce Dubonnet, who is one of our regulatory specialists out of our Chicago office, who's going to be talking about recent regulatory developments in this space. After Royce, we're going to turn it over to Jenny Price, who is a partner in our Richmond office, and she is an expert on product labeling, and she's going to be talking about some recent developments in that area. And then next, we'll turn it over to Ben Abel, who is an associate in our Charlottesville office and an expert on food and beverage labeling, and he will apprise you of some of the recent developments there. I will weigh in briefly about some of the trends that we're seeing in both product and food and beverage labeling. And then finally, we'll have a little fun and tell you about some of the developments that we love that we've seen recently and consistent with the Valentine's Day theme. And you'll probably see on this slide, there's a little heart there. And one of the things that we've done is we've sprinkled some hearts on some of these slides today, just to reinforce when we see something that we particularly like, that's particularly good with, that's particularly helpful to industry. So be looking out for those. Before we actually get into the content, a couple of quick advertisements. And I know I've mentioned this before, but one of the things that we do for our clients and friends is we have a monthly newsletter on labeling trends. That Ben Abel, who's on this, one of our presenters today, is largely in charge of, and it's a great resource for those who want to keep up to date on new developments. And then the other thing that I wanted to note, and this is fairly new, is we have a labeling and regulatory emergency hotline and dedicated email address for any emergency inquiries. And you'll see the email address and the phone number there, and if you ever have any issues and you don't know where to turn, you can call on that number or email that email address, and we will get back to you promptly. And then the only other thing that I'll mention before we get into the content is sort of a new project that we're planning on launching soon. And it's going to, I think we're going to call it the 2030 project, and it's really looking at what the trends are, not in 2020 or 2021, but a decade out. What do we think the product and food and beverage industry is going to look like with regard to regulatory developments and litigation developments in the year 2030? And so we will be getting together and sort of forming a task force with hopefully folks from industry and other experts in the field, and hopefully having a conversation and putting together some kind of white paper or whatnot on that. And we really look forward to having a conversation and dialogue. And if you have any interest in participating in that, please let any of us know. So with that, I will turn it over to Royce, who will get us going with regulatory developments.
Thanks, Trent. And let's jump to the next slide. So first of course, the big part here is going to be cannabinol or CBD and what's going on. Wanted to start out at the federal level this time. Just real quick, we haven't seen a lot of FDA warning letter activity in 2020. We're now kind of in mid-February. Not surprising there because the agency did a lot in 2020 or 2019, but that's not going to change the pace of what FDA is going after in terms of the disease claims, and some of the more aggressive CBD-containing products is not going to end, I think, in 2020. I still don't think in 2020 we're really going to see FDA have any substantial clarity on what their ultimate position is going to be on regulating CBD. But subtly, last week, FDA released basically some renewed positions on dietary supplements and CBD. We've seen a lot of action in the market right now trying to shift the labeling to calling products with CBD as hemp, basically saying hemp oil with 100 milligrams of CBD. My read on a recent FDA letter is essentially FDA reiterated its position that although there is hemp product out there that is generally recognized as safe, whole hemp seed protein powder, hemp seed oil, FDA clarified, and I think this is the main takeaway of their letter, clarified that when we said that these parts of the hemp plant were generally recognized as safe for human consumption, we did so with the point that there's only trace amounts of THC and CBD. So my takeaway from that is FDA is basically coming out and saying, look, if you're going to call your product hemp, it should be grass hemp, which is whole hemp seed protein, hemp seed oil with only trace amounts. If you're calling something hemp and it has 100 milligrams of CBD, or you say the words broad spectrum CBD, or anything that implies that there's CBD in it in more than a trace amount, I'm not saying that I've seen any action there unless you're making some more aggressive claims around the product, such as cures cancer, fights Alzheimer's. But I think that this is a good point to look at FDA saying, when we said it's grass, it means that it has trace amounts. Do they define trace amounts? No. But I look at trace amounts as, barely at the level of modern analytic testing detecting in a lab. It's kind of what I view trace amount as. I think there's definitely some case law and some leeway there, but just something to be mindful of, that this is kind of our first expression of thought from FDA right now in February. We're going to see more of it. We're going to see more warning letters this year. And I don't really think the ground rules of operation in this space have really changed. There's still going to be some risk, but there's tolerances to that risk in this space when you're using CBD as a product. So some other things to think about with CBD, and I did a lot of work the other week at the state level. In the absence of clear federal regulation on labeling, clear guidance on what can be a CBD product, what can't be a CBD product, states are moving forward and coming up with their own labeling laws. So part of the analysis when you're, marketing a CBD product, taking into account the claims that you want to make, the federal issues, what has FDA done out there already, what kind of space am I operating in, I think it really requires a state-by-state analysis, and I've said this before, but I think even more so it requires a state-by-state analysis. Just some examples of states on this slide, by no means all the states out there. There's a lot of other states out there that will have opinions on CBD, but the breakpoints are really this. Some states are saying CBD does not belong in food ever, period. Other states, which isn't on this slide, such as Louisiana, say there's a place for CBD if it's in an oil form, with Utah even going so far as to say you can put it in a gummy cube form, but you can't put it in the shape of a gummy fish or bear or anything like. True call with the Utah regulator. But Colorado, Oklahoma, and Maine have a little bit more guidance on the way CBD in food should be labeled on a product. And in those states, we're seeing some permissibility of CBD being in a food product at the state level. I've spoken to the Maine regulators. I've spoken to the regulators in Oklahoma. I've spoken with Colorado's DORA, which is the regulatory agency there. And it's important if you're going to sell product in those states that you follow the labeling requirements, the origin requirements for the CBD. But one of the large trends that I'm seeing is I'm seeing CBD labeling at the state level look more and more like the way you would see traditional cannabis labeled. And I am not advising on cannabis labeling by any means, but we're seeing that states are very obsessed with, and maybe as they should be, the quality of the CBD, the origin of the CBD, the amount of CBD present, and I think we're going to start seeing QR codes or other ways to convey more information on the label. And I think as regulators in these states get more sophisticated, we're going to see more complex labeling rules for CBD at the state level in absence of clear federal guidance. The other thing to be mindful of is at the state level, you have to check your permitting. You have to see, for example, in Oklahoma and Maine, in Louisiana, are these states going to require me to get a permit when I sell a CBD product in the state? Now, the big overarching question is there enforcement action here? I have not seen state-level enforcement action on the labeling issue yet. That's not to say that it doesn't exist, but most of the regulators I've spoken to are still trying to figure out how to get their heads around the issue and are actively drafting guidance every week. That could change, could not be solid. It's worth a call to a state regulator to figure out exactly what they want if you want the ultimate clarity. Next topic I've kind of seen emerging on the regulatory side is USDA a couple months ago released some more substantial guidance on what they consider raising claims. And from this picture here, this is from, and look, yeah, it's from Portlandia. It's a great skit on, where chicken comes from. But it's kind of highlighting the idea behind this slide, which is USDA came out, and if you all recall, USDA is a little different than FDA in that when you're in USDA-regulated industry, you submit your labels to physicists for approval. If they don't like it, it gets shot back down to you. If they like it, it goes on your packaging, and you get some protections there from, people challenging whether or not you lawfully labeled your product. USDA released a guidance saying, okay, our position on antibiotic-free means if you are saying that you have raised your chickens or cattle antibiotic-free, it means no antibiotics whatsoever. It means that at any time during the raising of the animals, they were never given antibiotics even for protection against bacteria, anything like that. When you say subtherapeutic antibiotics, you're clarifying that antibiotics were added to the animals only to protect against, only when they were sick or to protect against disease. What you can't do is you don't have the ability to, you cannot differentiate, or nor maybe you'd want to say, I'm adding antibiotics as bulking agents. The other thing to keep in mind is that all animals need to go through a clean period of, I think it's about 2 weeks. I'd have to check the reg again, but 2 weeks before slaughter, they need to get all the antibiotics out of their system. So if you're saying antibiotic-free because you've got that 2-week clean period, you might encounter some challenges at USDA with that. But it's important, too, if you're conveying what your animal has been raised on, how it's been raised. Is it, free range? Is it grass-fed? USDA has positions on that. The other important takeaway from USDA is they want the documentation now to substantiate where your claims are coming from. So if you put the claim on the packaging, be prepared for USDA to come back and say, okay, well, give me some analytic data showing what the animal has had in terms of antibiotics. Give me some information about the raising conditions of the animal. And to be mindful of that there are specific guidelines and specific document requests in the guidance that USDA wants, and to think about, all right, do I have those documents from my suppliers? Do my vendors give me those documents? If I'm doing my own slaughter and packaging, do I have those documents in my supply chain to qualify that? Just something to be mindful of if you're going down the line and you're going to be selling on a raising claim, to have the documentation to be able to tell USDA that that's the case. Finally, just on the nutrition facts label, January 2020, USDA released an updated small entity compliance guide. I really like small entity compliance guides a lot, and I think that they're really valuable things that USDA does because they're really the no-nonsense, this is what you need to do as a small business on how to follow the changing labeling law out there. and I think it's plain English. It's pretty easy to understand. It's not as detailed or as complex as the full regulations or the full releases in the Federal Register, but it's a great place to get your head around the labeling. One of the important things that USDA reemphasized in this was, not all foods need to count added sugar. There's been renewed emphasis within, FDA and USDA on added sugar and some of the health concerns around added sugar that the agencies believe are present. If you're making something like honey or cranberry juice or something like that, there are exemptions within for declaring added sugar, and it's important to be aware of that. If you make some products, for example, honey is a enforcement discretion on that. They're not going to go after honey for not declaring added sugar. Maybe it should be there, but they're not going to go after it right now. Certain juices are not required to say we have added sugar to them. So just take a look at that small entity compliance guide and figure out whether or not you really need to be conveying the fact that you have added sugar in the product. You certainly don't want to, if you want to convey that, you're welcome to, but my opinion is you never really want to do anything that the regulator says that you don't really have to do unless you believe there's a reason for that. Some other important things, vitamin D, potassium are public health significance ingredients, basically meaning that daily values have been established. There's going to be more emphasis placed on vitamin D and potassium added to food products. There may be a discussion down the road about how you do that, what you can market on, and what products can have those added to them without violating the junk food rule. Junk food rule is basically you can't take something like a candy bar, add vitamin D to it, and call it healthy. But with public health significance ingredients, it would be worth a look to see, where does that fall into place down the road. Dietary fiber, lots of new things will contribute to dietary fiber count. I'm happy to give more specific answers on that in a Q&A, but it's important to figure out in your product what needs to be counted as dietary fiber, what can't be counted as dietary fiber, because I think that there's going to be renewed emphasis by FDA looking at that. And Trent, did you want me to talk on this, or did you want to take tofurkey?
Yeah, I can talk for just a moment about tofurkey in the next slide, Royce.
Okay, got it.
All right, thank you, Royce. I really appreciate all of that. And I'm going to talk briefly about tofurkey, in part because tofurkey has to be one of the top 10 most fun words to say in the English language. And as most of you know, meat and milk alternatives is really a hot issue out there right now. There are a number of states that have either considered or have actually enacted laws sort of barring companies from using words that would suggest that it was meat, like burger or sausage, for plant-based foods. And this is a fairly significant decision that came out back in December. And it basically, the court in the Eastern District of Arkansas found that this law barring companies from using burger and sausage for plant-based foods was likely unconstitutional. And so I think this is significant and something that we should keep an eye on, this development. One other thing I'll note is that I know that just earlier this month, there was a lawsuit that was filed by a company in California, also seeking to declare California's law and regulations related to this as unconstitutional and violative of the company's First Amendment rights. We don't obviously have a decision on that yet, but that lawsuit involves whether or not this company, which is called Miyoko's Kitchen Inc., can use the word butter to describe its vegan plant butter. And so that's the issue there, and it'll be interesting to keep an eye on that going forward, as well as some similar lawsuits in some other states. One other thing that I wanted to note before we move on to product labeling and Jenny is processed meats. Processed meats is, I think this is a little bit under the radar, and you know, it's not new that this has been something that has been targeted for some time by some of the interest groups out there, but they continue to target it. And here is a lawsuit that was filed attempting to prohibit school districts from serving any processed meats. And, you know, fortunately for industry, the court dismissed the suit, finding that there was no requirement to refrain from serving processed meats. But I just wanted to flag this because it continues to be a topic that is a target. One other thing I'll note that's not on the slide, but there's a citizen petition related to uncured meats out there as well right now that was submitted by Consumer Reports and CSPI to the USDA, asking it to prohibit uncured and no nitrate or nitrate added claims on meats that have been processed using non-synthetic sources of nitrate or nitrite, such as celery powder or sea salt. So that's something else just to keep an eye on. And with that, I will turn it over to Jenny, unless, Royce, you have anything else you want to add on the regulatory front.
Yeah, I just wanted to mention one last thing that for whatever reason, didn't get into the slide. California Prop 65, we did see California's Office of Environmental Health rule recently that THC, Delta-9 THC, is a known birth defect causing ingredient in California. What we don't know yet is what the enforcement action will look like there. I don't know if we have values or quantities established yet, but it is something that kind of slid under the radar, where I believe now Delta-9 THC is on California's list of products known to cause birth defects. Important to take into consideration because not all CBD products are going to be scrubbed completely of THC, but at this time we don't really have clear guidance on that, and it could mean down the road that you're going to start seeing CBD products with perhaps a Prop 65 warning, but I'm not forecasting that yet until we get a little bit more clarity about what's going on in California.
Thanks, Royce. This is Jenny Price, and I'll pick up from here on product labeling, and these are just a couple of the products that we're going to talk about in the next slides. So these first two cases I'm going to talk about are an update on previously reported cases. I think we talked about them either in the October or the May webinar that we had a couple months ago. The first case is really just an update that they're seeking class certification of a California class on the Rawlings mislabeling, alleged mislabeling of the non-wood youth baseball bats. They are claiming that the baseball bats were labeled at a certain weight, but they actually were sold 2 to 3 ounces heavier than their advertised weight. The court had previously dismissed the breach of implied warranty and the unjust enrichment claims, and that's what we had previously reported on. But the case had moved forward under the California false advertising and competition claims. And so now the case is at the class certification stage, and so we will keep you posted on that. But I just wanted to update the group that the case has been moving forward, and it's something that we're keeping our eye on. The next is the Aloe case out of the Northern District of Illinois, which had granted summary judgment due to lack of sufficient evidence that the aloe products at issue do not relieve sunburn, as the companies claim. This argument was before the 7th Circuit on January 15th of this year, and based off of Judge Easterbrook's comments and questions, it looks like he is in agreement with, at least he's in agreement with the summary judgment that the Northern District of Illinois had granted. He was very skeptical, at least based off of his questioning, that plaintiff's counsel didn't have any science to back up their claims that that the aloe Verigel was not effective in relieving sunburn. So we will keep our eye out on the decision from the Seventh Circuit, but based off of the questions at oral argument, we're hoping that that will be affirmed. The next case that we wanted to talk about has a red heart by it because it fits in with the theme of Valentine's Day and cases that we love. This was a case that was brought against SanDisk for allegedly mislabeling its flash drives and memory cards because they were confusing to the consumer in that what they meant by gigabyte. So apparently there's a discrepancy between what gigabyte means, which I didn't know until I found out about this case. It can either mean 1 billion bytes or a number a little bit, 73 million approximately more than that. And the claim by the plaintiff was that it wasn't clear on the label whether or not SanDisk meant the 1 billion bytes or the more than 1 billion bytes, and that they were deceiving consumers by not disclosing that. But in fact, there is a disclosure on the packaging and on the website, and I pulled the disclosure that's on the SanDisk website. That's what is right by the heart. That has a little word that says disclosures with an asterisk, and it explains that pursuant to SanDisk, when they say 1 gigabyte, they mean 1 billion bytes. And the judge saw that, and while acknowledged that the disclosure is small, said it was readable and not illegible, as the named plaintiff claimed, and actually dismissed the case with prejudice. So that was something that we wanted to make you guys aware of, and mark with a red heart as something that we like to see as defense counsel. The next series of cases relates to Purell, and the FDA had sent a letter to Gojo Industries, who is the maker of Purell, regarding their healthcare advanced hand sanitizer that they were marketing on their website and social media as effective in fighting Ebola, norovirus, and the flu. And the FDA basically was saying, you don't have any credible scientific studies and well-controlled studies that demonstrate that that claim is accurate. And so they sent them an FDA letter on January 17th of 2020, and the New York case, the Southern District of New York case, class action, was filed by February 1st, which shows you just how quickly the plaintiff's counsel turned around a nationwide class action lawsuit just in a couple of weeks. And there were also at least 2 California class actions that were also filed around that time. So we've been seeing this a lot in the CBD world, where the FDA issues letters, and then the FDA letter is quickly followed by class action lawsuits, and the same thing is going on here with Purell. FDA letter issues, and then multiple class actions have been filed, and I'm sure that we will continue to see more class actions filed against Gojo relating to this Purell claim. The headphones class action, I just wanted to highlight that there was a settlement deal that was approved by the court out of the Northern District of California, and it relates to the Backbeat Fit waterproof headphones. They cost between $60 and $90 approximately, and the settlement approval gives 3 different options for class members. And I wanted to just highlight this because of how expensive it likely will be for Plantronics. But with the headphones costing $60 to $90, the settlement approval is a $50 reimbursement if the class member can establish proof of purchase as well as proof that the battery failed, either with performance or charging issues that was related to waterproofing, sweatproofing, or moisture. $25 with just proof of purchase and proof that the headphones don't work, or a replacement if issues with battery performance or charging and waterproofing issues are established. 650,000 settlement notices were sent out, and there were about 50,000 submitted claims. So it's a pretty big number for individual claims compared to what we have seen in the food world, where it can just be 20 cents or something like that. It's a pretty big individual claim. So I just wanted to highlight that for y'all. And finally, the last matter that we're going to talk about is the Peter Thomas Roth case that is currently pending in the northern. That's currently pending in New York. No, I'm sorry, the Northern District of California. I was right the first time. And this case is, it was a class action, and class certification was denied at this point. And it relates to two products that Peter Thomas Roth makes, the water drench products and the rose stem cell products. They're both anti-aging products. After class cert was denied, defendants filed a partial summary judgment that was denied, essentially saying there's still issues of fact that need to be decided, and this is not just mere puffery, saying things like the product can regenerate and rejuvenate and hold 1,000 times its weight in water, are not just puffery statements, and there are issues of fact here that need to be decided by a jury. Interestingly, plaintiffs have also now filed a summary judgment that will be heard in March, and we'll keep you posted on that. But their claims are basically that Peter Thomas Roth did not do any scientific studies or research to back up their claims that they make about the rejuvenation, regeneration, and holding 100,000 times its weight in water. And so they're entitled to summary judgment on those issues. And again, that will be heard in March as long as that schedule continues to hold. And we will certainly keep you posted on that. Ben?
Hey everyone, this is Ben Abel. I am going to go over some recent developments and trends we're seeing in the food and beverage area in terms of litigation and labeling. Two quick things. One based on who had signed up, and then looking at who is actually on the call today. We are overwhelmingly packaged food and beverage. To the extent that you're a retail company or have a retail arm or interested in retail, would love to talk about that with you. And there's some interesting stuff going on in retail, especially with descriptions of products. There's a suit challenging Burger King's Impossible Whopper, saying basically it's not 100%. There's the no beef claim isn't true when you cook it on a grill that's also used to cook regular beef Whoppers. There's also been a suit filed against Benihana related to its fake crab, and a recent motion to dismiss that was granted against P.F. Chang's related to fake crab used in some of its sushi rolls. The basis of that claim essentially being that, well, they spelled crab with a K when it wasn't real on the menu, and you consumer, a reasonable consumer would have known the difference. So the first is we'll mostly focus on packaged issues today. The second is, and to tie in with Royce's comments on CBD, we saw last month the Southern District of Florida issue a stay in the CBD labeling case related to, I think, gummies and oils and some other ingredients, and basically say, sure, Florida has decided to regulate CBD and says what it thinks it means, but FDA hasn't yet, and boy, it sure would be helpful for FDA to tell us what it thinks about CBD, and so it stayed the case. So looks like CBD, in terms of the spate of recent lawsuits we've seen related to CBD products, may go the way of natural, in the sense that the courts are all going to issue stays and wait around and twiddle their thumbs until either they get too impatient or FDA finally acts. So we'll keep an eye on that, but that looks like what might be occurring with CBD litigation. The first issue we wanted to talk about is a new series of suits that we've seen in the past couple months related to slightly sweetened or similar claims. So we've seen at least three of these suits be filed in either the Southern or Eastern districts of New York. One related to Honest Tea's Just a Tad Sweet, another related to Stee's Lightly Sweetened, and a third related to Gold Peak's Slightly Sweet, all of those teas. The claims essentially say that a slightly sweet claim on the label, well, that's really a low sugar claim, and low sugar claims or reduced sugar claims aren't allowed under FDA regulation. FDA, the complaints allege, has enforced in this area in the past, and basically you're tricking consumers. They are interesting not only because it's kind of a novel claim, but they for a couple of reasons. One being there is a weight loss component to the complaints, and they sort of read like they are a second, more clever or at least different bite at the diet soda apple. Of course, remember the claims that diet soda falsely implied that you were going to lose weight if you just drank Diet Coke or Diet Pepsi. Those were largely unsuccessful, and these seem like a second attempt at that sort of claim. The second, from a more practical consideration, is these are being brought by the same plaintiffs' attorneys that have been suing the industry related to vanilla. And we'll talk about the vanilla suits briefly in a moment. But what that means is if their past patterns hold, they are going to go up and down the aisle, the grocery aisle, and sue anyone making this claim. So to the extent that you have a SKU with a claim similar to this, it might be worth reviewing the labeling and reviewing any litigation risk associated with it. Nothing more than the initial filings, other than the Center for Science and Public Interest petitioned FDA for rulemaking related to this claim. So there is an industry push from consumer advocates and consumers regarding this claim, and that should be some sensitivity that people realize is out there going forward. We also wanted to provide an update on country of origin and region of origin labeling. We have continued to see some definition to what the courts hold as either an okay, permissible claim or is something that might cross the bounds and at least survive a motion to dismiss. We previously talked about the Kona Brewing settlement related to the Kona beer. We also talked about the Cascadia Farms, Washington frozen vegetable and fruit litigation. We saw a couple of opinions. The first relates to Kona coffee. There actually were two different opinions because there was one suit that's brought by consumers alleging that Kona coffee is being sold by companies that aren't actually sourcing their coffee from the Kona region of Hawaii. And then there was a second suit. We've seen this a couple times from suppliers, from farmers who actually grow Kona coffee, saying that they're being harmed as well. And the court dismissed some of the claims, dismissed claims against certain retailers, basically saying that they couldn't be on the hook for claims made or by labeling claims made by the manufacturers themselves, but largely said there was sufficient pleading in the record that there was labeling and slogans on the packages and in marketing that tied the product to the specific Kona region, that it could survive and continue. That was also followed by a suit related to Cento tomatoes, the yellow can, which I'm sure you're all familiar with. And the allegation there is that Cento tomatoes are not actually grown in the San Marzano Valley, or aren't certified by the proper certifying entity, certifying that the tomatoes are grown where they say they are grown. And that got past a motion to dismiss, and the court held, again, there were enough specific allegations about specific claims being made that it was at least ambiguous, if not deceptive, where the labeling claim was. In large part, again, that dealt with a specific region that the tomatoes were being tied to, and again, with specific entities that were certifying them, you start to get more into specific claims about the tomatoes as opposed to a more generic, geographic, St. Louis style barbecue or something like that. And recently, we've seen two suits that were filed in New Mexico State Court that were removed to New Mexico Federal Court. Again, one by consumers and another by producers, related to country of origin labeling for beef. As some of you may remember, following a dispute with the World Trade Organization, the U.S. no longer has regulations as to beef and pork country of origin labeling. And so these suits allege that USA claims, produced in the USA claims on certain meat products are deceptive to consumers and trade on the back of strides that the beef industry in the United States has made to be sustainable and humane, and foreign producers are trying to piggyback off of those, no pun intended. Those have just been filed. They've been coordinated for motions to dismiss, for the purposes of motion to dismiss. We'll see what happens, but this continues to be an area where there is a lot of action in some developing case law. Next, wanted to touch on some positive developments we've seen with malic, citric, and ascorbic acids and other acids. If we probably went back and pulled the presentation we gave a year ago on this was the cause celeb in the industry that basically anything with a citric, malic, ascorbic, other kind of acid ingredient that made a flavoring or preservative claim, you could expect your demand letter, if not an outright lawsuit. We talked last time about the Kraft decision out of the Northern District of Illinois. That was a citric acid claim, and the court dismissed it and said, plaintiff basically said, the product has citric acid in it, and sure, I don't know if that citric acid is artificial or natural, but come on, Kraft Heinz is a big company, and surely they're using artificial. And the court said, come on, you have to do more than that. You have to actually allege that the citric acid in the product is artificial if you're going to challenge a no artificial claim. That was followed by the Clark decision related to Brookside dark chocolates out of the Northern District of California, and that was on summary judgment. And that court, again, that was a malic acid claim. Hershey had said that they were using the malic acid basically to help bind the product together so that you could have chocolate surrounding a fruit center. And plaintiff in his one of the plaintiffs in his deposition said he interpreted no artificial flavoring really to mean no artificial ingredients. And the court on summary judgment said, well, there is a difference between no artificial flavors and no artificial ingredients. There was no evidence that the malic acid being used was actually being used as a flavorant as opposed to a binding agent of sorts. And the court dismissed the claim. It dismissed a couple other named plaintiffs on standing grounds. But two decisions is not a definitive trend to make, but I think the industry has been very happy to see some pushback from the courts on these citric malic ascorbic acid claims. There was a real concern that these were just going to dominate the industry. But where an acid claim goes poorly for a manufacturer, it can be expensive. Ocean Spray agreed preliminarily to a $5.4 million settlement of a synthetic acid claim. And that was after the class certification stage, which we'll talk about in a moment. But these claims can be expensive when they exist, but we've seen some positive results from the courts. Trent, you want to talk about maltodextrin?
Yes, and thank you, Ben. And I told Ben that I wanted to do maltodextrin because maltodextrin is a little bit of my baby. I've been telling some of my clients for years to watch out for maltodextrin, and then this result came down recently in Alabama, which is not a sort of a hotbed of food litigation. But while the court dismissed some of the causes of action in this particular suit, the court did allow the one for maltodextrin to proceed. And it's a very similar sort of theory to what Ben was talking about with malic acid. So I think that's something to watch out for, not just maltodextrin, but other sort of, quote unquote, synthetic ingredients as well going forward, because I think the plaintiff's bar is looking for new targets, and maltodextrin and other things similar to malic acid may be them, some fruitful targets for them going forward. So that's all I wanted to mention. I know we're running short of time, so I'm going to throw it back over to Ben.
We'll talk very briefly about the vanilla cases that I'm sure the vast majority of you are aware of. They continue to be filed. They continue to be filed en masse. Given the way the Plaintiffs' Counsel is structuring it, we haven't seen a ton happen. I'll just say that there is one public settlement involving claims related to Califia Farms, which is going to be is proposed to be on a class-wide basis. Is going to, there is some California state litigation that's going to be resolved by it as well. There also were apparently some other non-vanilla claims. All that is to say, the proposed settlement is for $3 million, which is a lot of money. For those of us who are involved in this space, involved with these lawsuits, that is a big number to have the first public settlement be proposed. So keep that in mind if you have one of these suits. There are some that are proceeding to the motion to dismiss stage. They almost all of these, except for one I can think of, are pending in either the Eastern or Southern districts of New York, and some of those individual judges have sort of a mother may I submit a letter saying why I should be allowed to give a motion to dismiss. They've proceeded to there. They're in that process, but we have yet to see any court make a ruling, good or bad, as to the vanilla litigation. And finally, just some basic, a couple class cert denials, which as a defense-sided attorneys we like a lot and gets the heart from us on the slide. The first related to no artificial flavors on Pringles. The court held that the named plaintiff was not representative of his class. You'll be shocked to know that, given that he was a pastry chef by trade who was very much into gastronomics. and who apparently said that money was no object to him. And the court thought, gee, you might not be the average Pringles consumer. There also was an individual issue, given that only apparently 4 of 20 challenge labels actually included the challenged claim. And the court basically held it was going to have to take way too much work to try and figure out who saw which of those 4 of 20 labels. The other one we have here is the Champion Pet Foods suit. Again, class cert was denied, again on individual issues, because part of that was going to have to deal with issues related to each individual bag of food that was purchased by the consumer. So not only are we just happy to see class cert denials, but it's also a good reminder that, looking at long and hard at who your named plaintiff is, and if you can make individuality issues predominate, it might be helpful to getting class decertified. And just a reminder, though, that when class is certified, that can ratchet up what the settlement value is going to be worth. We saw that with Ocean Spray. And McCormick has agreed to a $2.5 million settlement related to Slackville in its pepper grinders, again, almost as soon as class certification came down. So with that, I'll turn it over to Trent.
Thank you, Ben. And I'm going to move quickly through a few of these slides. These are just some additional trends. The first one is CBD class actions. And some of you are probably aware that we did an entire webinar on this last month. And I believe the recording of that and the slides are still up on our website. So if you have a burning desire to know everything that can be fit into a 1-hour webinar about this topic, please check that out. I'll just note that we're starting to see sort of a wave of class action litigation with regard to CBDs. And there are a few basic categories of the types of CBD class actions. One is illegal to sell, one is too little CBD, one is too much CBD, and then there's securities lawsuits. I'm not going to go into it any more than that, other than to mention our prior webinar if you'd like to know more about it. I think what Ben said earlier in the webinar is correct, that we're no doubt going to see some courts, and we already have seen some courts punt and say we're going to stay these cases based on primary jurisdiction until the FDA can come down with some comprehensive guidance. And aside from that, we don't really have much in the way of results on some of these cases just because it's so early, but obviously something to keep an eye on going forward. Something else that I think, and we haven't really seen a whole lot of these suits yet, so this is almost more of a prediction. I think that we're going to see a lot more of PFAS and pesticide suits related to their presence in food. And, if you just sort of look in the news, there's a lot of articles about PFAS and about, various companies' liability for them. I saw one of the main companies had, spent $250 million last year in litigation. Of course, that's personal injury, but you're starting to see some states really look at this in terms of food and packaging for food. And so you see a couple of things I just wanted to flag here. States like Maine and Washington have passed legislation banning PFAS in food packaging. The state of Washington is currently analyzing whether there are, feasible PFAS-free food containers. You see some in the industry voluntarily banning them, and you see the FDA expanding the number of foods in which PFAS can be detected. Same thing with pesticides. I saw an article recently in the past couple of weeks that the biggest manufacturer of one of the chief pesticides announced that it was going to stop production of it by year's end. So just something, and that sort of is similar to the glyphosate discussion that we've had on prior calls, just something to keep an eye on going forward. Simple and fresh, another one. There's been a few recent lawsuits that have been filed. And we've seen these before, but I think the point I wanted to make is these continue to apparently have some legs. There was one targeting Simple for some hot chocolate filed back in November. And then there was a motion to dismiss denied in December related to fresh and biologically appropriate claims on premium dog food. So obviously, if you have simple or fresh on your packaging, just give some hard thought as to whether or not that gives some risk for future litigation. This is something that I know that Ben has already covered, but I just wanted to flag one thing. This is a lawsuit that was filed late last month against BA Sports Nutrition, and it basically said that it had too much sugar, that it's camouflaged junk food, and that it's really a dressed-up soda masquerading as a health drink. We've seen these type of suits before. They're continuing to be filed, and something that we obviously have to keep following. And then finally, my last trend I just wanted to note is we continue to see some out there claims from plaintiffs' counsel, some of which are getting past the motion to dismiss stage. And I just wanted to flag a couple of these. Here's one where the grains of paradise as an ingredient in gin, Bombay Sapphire actually, was targeted and the claim was that grains of paradise made the gin adulterated according to an 1868 state statute in Florida. Well, fortunately for all of us who liked their gin and tonics, the court said that they dismissed the claim and found that the state statute was preempted by FDCA and found no actual injury. We also have the Burger King Impossible Burger suit about whether it was deceptive because it is being grilled on the same grill as meat burgers. And Burger King basically said, we've never said it's vegan. So, we'll see what happens with that. We don't have a result in that yet, but want to keep an eye on. And then finally, this is one that was actually reinstated. It was dismissed, and the Ninth Circuit reinstated it late 2019, and it has to do with double shot espresso. And it basically said that there wasn't as much caffeine in the product as you would get in a double shot of espresso. Therefore, it's a plausible claim to move forward with. So a little bit of, I think, what a lot of the industry would believe is a silly claim is getting past the motion to dismiss stage and going forward. So those were just a couple of things. And then finally, we're going to talk just very briefly about a few developments that we are very happy with. And I'll turn it over to Ben, Ben, if you could maybe just spend 30 seconds to a minute talking about what you love.
Yeah, we love a reasonable consumer test, especially with the diet suits. I think there was some concern that while the Second Circuit had ratcheted up the reasonable consumer test, the Ninth Circuit might not follow suit. And in Becerra, they also dismissed the claim. So we're happy about seeing a more exacting and demanding reasonable consumer test.
And Royce, I know there was a couple of things that you wanted to say as well. Actually, before you do that, Royce, I just wanted to, you'll see some of these slides that we're not going to have time to get to, including one about the Becerra suit that Ben just mentioned. And there's even a recent decision in California State Court that we actually were able to put a heart by, which is shocking, not something we see very often. So you can check that out in the slides. And now I'll turn it over to Royce, who I know he had one particular thing he wanted to say about CBD compliance.
Yeah, I think what I like about CBD is that there is a dialogue and conversation being had with the state regulators. Every state regulator I've spoken to so far on CBD and hemp issues has been extremely appreciative to have the conversation to discuss the way they want things to look. I've also found, state lawmakers in general, based on, my work with McGuire Woods Consulting, to be receptive to this as well. I'm also really like how, although I don't agree with FDA all the time, that they are still releasing information in this space about their positions, their views. I would like for them to put the final nail in the coffin on what they think about CBD, but there is ample material out there that FDA is publishing that allows us to guide clients in this space.
All right, thanks a lot. And then the final thing that I'll mention is there's a number of class issues out there, and I think there's a question about whether they're trending in favor of defendants. Not everything is. I wanted to flag the Bristol-Myers Squibb test in class actions. It's an open question right now. 2 circuits are considering it. We don't have decisions. If you were a betting man or woman, you would probably bet that those circuits say that Bristol-Myers Squibb cannot be used in class actions, but that remains to be seen. But on a lot of these other ones, standing and jurisdictional issues, we're seeing courts, really looking closer at class actions and whether class actions should actually be certified here. So, and here are just a few examples from recent decisions in recent months that support that. And there was also, I think, one that I wanted to flag that from a procedural standpoint was really nice to see. And this was the Clark v. Hershey's case in the Northern District of California, which makes it significant because in my experience there, courts often give plaintiffs every single opportunity to be successful there. And here's an example of where the court granted summary judgment last year for Hershey's in this case related to artificial flavors and malic acid. And some new plaintiffs sought to intervene and amend the complaint. And the court said, nope, you can't do that. That would be a backdoor attempt to begin the action anew. So that was a very hopeful sign, and that also earned a heart from us. So with that, thank you so much, everyone, for joining us today. If you do have questions, please feel free to email or call us. We love talking about this stuff, and we would be happy to take your question and get back to you as soon as we can with some kind of answer. And we really appreciate y'all taking your time to listen to us today. Thank you so much.